And Judge, approaching is Ms. Brenda Maxwell in case number 23-930 CFMA. Judge, as you may recall, Ms. Maxwell was previously evaluated for competency and was in fact found competent to proceed. Mr. Sullivan has extended a plea offer of possession of methamphetamine, a withhold of adjudication, and only 18 months of probation. The issue I'm having with Ms. Maxwell is that she wishes to be charged with a firearm. She's worried about her co-defendant being charged for it. I've tried to explain to her my job as a defense attorney is not to make things worse for her, to get her out of this as easy as possible. But Ms. Maxwell is wishing to not, if I understand correctly, to not accept this plea offer because she wishes to be charged with an additional crime.
That's not your
Yeah.
decision to make.
My fingerprints are on those guns.
Don't care.
Both of them.
Listen to me. Just because you want to be charged with something doesn't mean that the state has the obligation to charge you with anything. So if that's what's holding you up, you're messing yourself up.
Well, I'll just do what's right then, because I was just trying to do what's right.
Well,
Because I took them in that car and my fingerprints are all over them, both of them.
And I've explained to Ms. Maxwell, she could certainly testify in that trial if the state or the defense wished to use Ms. Maxwell as a witness in Mr. Albritton's case. Mr. Albritton is the name of the co-defendant. I believe his first name is Grover.
Matt.
Matt Grover.
what in the world would you want to be charged with?
Well, and Your Honor, not to go too far down the rabbit hole here, but before Ms. Maxwell is put under oath at all, either for the colloquy or if she decides to testify, I would point out that there's the in-car camera that captures Mr. Albritton trying to convince Ms. Maxwell to take possession of the firearm in the car so that he doesn't get charged with felon in possession of a firearm. So just so she's aware of what perjury is and that I have the evidence of Mr. Albritton trying to convince her to take the blame for his actions. I just want to point that out there.
Can I say something?
No, ma'am.
Anything?
What does it matter? Good gracious, you've been charged with a felony. And you've got a plea offer, I guess, that you would take, and you're.
Sir, can I say something? When I got in the back of that car, I
If you
said,
want to
how
say
am I-
anything about the case, I don't care.
I didn't know
ma'am.
how I was
Listen
going to
me, I don't
explain
care
having
to
the
hear
two
it. No, ma'am.
guns.
Either
The one I malfunctioned, and that's the reason I had two. And I
don't care.
asked.
Listen to me.
Yeah. You're going to
Okay.
get yourself in
Care.
trouble.
Absolutely could not care less. Either you want to take the plea or you're not, but you cannot direct the state what to charge you with.
Can I testify if I get with you and explain what happened?
I can't prevent you to testify from anything, but I
Well,
just.
I mean, testify. Can I be a witness for him?
That's up to his
Yeah, That's
lawyer.
up to the defense attorney that represents Mr. Albritton.
Look, I've heard all this on
Yeah,
here.
we can pass
Okay,
it if
we'll
you'd like
just
to.
say
Your
that.
Honor.
Hold on, let me see. I've got an affidavit for violation of her release.
Yes, Your Honor. There was one. I believe you had ordered her to be present back in September on
Maybe
the
I had,
12th.
did I have another one? I
I'm
don't
not,
see one. All right, well, she's taking care of that. All right, what are we gonna do? We're gonna set up for a trial or on the possession of
Yes,
methamphetamine?
or do you want to resolve it today
I
with the
guess-
withhold?
I guess I have to resolve. If I can be a witness, I'll resolve
Okay.
it.
Ma'am, I can't tell you you're gonna be a witness or not gonna be a witness. I got nothing to do with that.
And Your Honor, just for the record, my advice is to accept the plea. She has an opportunity to walk out of this courtroom without even being a convicted felon or a convicted criminal. With only 18 months of probation, any effort to make things worse has not been my legal advice. This is partly what led to the evaluation for competency in the beginning. Would you like to resolve it today?
I guess
Okay, there you go.
I really
Madam.
found the stuff, so I'm really not even guilty of this.
All right, forget it. I'm not taking the plea. I'm
Okay.
not gonna take it. We'll set it for trial. We'll set it for trial.
It's
No,
okay,
ma'am. No, ma'am. I'm not taking it. No, ma'am. No, ma'am. I've heard enough.
sir.
No, ma'am.
I need to get.
No, I'm not taking it right now. You can talk to Mr. Saline. I'm gonna set it for December 12th. We'll set it for 10:30. You can talk to Mr. Saline and I may take it then, but I'm not taking it today when you're saying I'm not guilty and I'm not.
No, I'm talking about the drugs. I found.
That's what you're pleading to. You need to talk to Mr. Saline before you come back up here.
And Your Honor, that's 10:30 on December the 12th?
December 12th at 10:30.
Yes, sir.
All right, man, step over and sign a notice. We'll see you then.
Yes, I did. She just kept encouraging me to get a court-appointed attorney, and I I simply said I don't want to, and she's very frustrated over that.
Your Honor, Maria Pinchenko for the record. I tried to resolve the motion with Mr. Hill. I explained to him my position that there's no legal basis that has been written into the motion, that I believe the motion should be dismissed, that it is simply a statement of facts of his opinion of what transpired of the case. I am uncomfortable dismissing the case or stipulating to the motion because I do not believe there's a legal factual basis. I explained to him that that is what I would have told his attorney if he had one. He has indicated that he would like to set this matter for a jury trial. I also indicated to him that he should, and I encouraged him to get a court-appointed counsel. I am not frustrated with his not getting court-appointed counsel, Your Honor. It's very difficult to speak with Mr. McCart. He keeps interrupting me. So I do want that on the record that I did attempt to try to resolve the matter. It appears that we'll be setting it for a jury trial after your ruling, depending upon what your ruling is on Mr. McCart's motion.
All right, Mr. McCart, would you like to place your motion on the record? You have to be brief. This is not a trial.
Yes, I filed this motion because of what he said, and I know what happened. I was there that day. My uncle tripped out the door, and my uncle went to the arraignment in Judge Toko's courtroom and said I did not assault him. He came to court and admitted this. And, I was not interrupting her. She would not give me a chance to speak. She just kept telling me what she wanted me to do, and that's not how it works. Now, me as my own attorney, I can go to the courthouse and get these transcripts from Judge Toko's photographer, file this motion as my own attorney at a trial. That's simple as that. That's all I want to do.
Mr. McCart. What are you in on? Because you're not in on this.
No, I have a drinking problem. I got in some trouble in Warren.
How long are you in for?
I've been in for 33 days. I'll be out next week. Yeah, I'll be out next week. And then I will go file to get the transcripts.
Here's what I'm going to do. I have reviewed your motion, and I can only grant things that are legally able to be granted. This motion to dismiss is only a statement of fact. Statements of fact need to be taken to a trier of fact, and that's a trial before a judge or a jury. There is no legal basis for a dismissal at this time based on this motion. So I am denying your motion to dismiss. We're going to set it for a jury trial. I'm going to set it for December 8th, 2023 at 8:30 a.m. in person in my building. Your bond is continued, so you are not held on my case. You're going to be in my building December 8th, 2023 for your jury trial. I am going to appoint what I'm going to call standby counsel. I'm going to allow you to represent yourself, but I am going to appoint an attorney to sit with you while you represent yourself, so that if you have questions on the legal aspect of how a trial is conducted or what to do, you have someone. It's kind of like a phone a friend. You'll have someone there. I'll allow you to represent yourself. I'll respect your wishes, but a jury trial can be a lot to handle when you've never done one before and you're not trained on how to conduct them. So I would like an attorney there for that process, okay?
Okay, thank you. I can respect that, Your Honor. I'm only wanting to represent myself because I can't afford all these attorney fines. Every adjournment, I get recharged. I know this.
Actually, I waive all court-appointed attorney fees, so you're not charged in my court. So would you like an attorney just to have one? You won't pay for it.
Yes.
I will waive them under the indigency rules.
I really never asked for a jury trial.
I don't want you to have that concern. All right. So do you want me to just appoint an attorney then, now that it's not a cost issue?
Yeah, sure. I have 2 daughters I'm supporting. I appreciate that. Thank you.
It's a non-cost issue. So here's what we're going to do then. I'm going to deny your motion to dismiss, but since we're asking now, we're going to officially appoint an attorney. I'm going to appoint an attorney, but we're actually going to set you for a pretrial before that jury trial date so that you can get to know your attorney and talk to them and not just come in on a trial date. Okay, so you can have some time to go over stuff with them. So we're going to set a pretrial up for December 6th, 2023 at 8:30 a.m. We'll set that up we'll set it up in person. That way you can talk to someone in person. I think you might be more comfortable with that. And then after that, if you still want a jury trial date, you can set it up with that lawyer, okay?
Can I ask you one question, Your Honor?
Yeah.
Is that okay?
Go ahead.
On my arraignment, when we sat in front of Judge Toko, my uncle actually came in. Does it mean nothing that he told her I did not assault him? It was a misunderstanding.
You know what,
That's-
sir? The thing is, as judges, we can't dismiss cases without a trial or without a legal
Okay.
basis.
So
So that's
take the
between
trial.
him and what happens at the trial. You should talk to your attorney about that. I don't know what he said. I was not at your arraignment. But once the
Right.
police are called and someone asks them to come out, it's not their choice whether charges get filed anymore. Then it's between the police
Okay.
and the prosecutor. And whether they
Right.
want to go forward, that is a question for whether or not they talk to the prosecution about that.
Right.
That's not something that they can come in and just tell me or Judge Toko,
Right.
because we're not involved
Right.
in that portion. We're here to have court available for hearings, and that would be things like pre-trials and trials. We're not here to just choose to dismiss cases.
All right.
Okay.
Thank you, Your Honor. Thank
You're
you.
welcome. We'll see you back on December 6th for a pre-trial.
Yep.
Have a good day.